Do you know how employees are terminated because of gross and habitual negligence? Is this allowed under the law, and what is the process for doing so?
Our episode today involves an employee who is contesting her termination. But people on both sides can learn a lot from this, both the employer and the employee. Now, our reader Angelique V wants to know about neglect of duty as a just cause for terminating an employee. So let's read her question. Good day, attorney. I was dismissed by my previous employer with alleged negligence of my duty. I'm thinking of filing a case with the NLRC for illegal dismissal. To add, recently I requested for my COE or Certificate of Employment, but they said that they would not issue my COE and ITR or income tax return if I will not accept the final pay, which comes with the condition that I won't file any case or won't hold anything legal against them. Please advise po kung tama yung ginawa ng previous employer ko. Salamat po.
But before we answer that, Attorney Ramon, we would like to give a shout out to one of our followers, Jovi.
Hi, Jovi.
Jovi enrolled in our workshop, the Complete Employee Discipline workshop. And she says, highly recommended. Really love the sessions. They really made me feel confident in handling cases and creating imposing rules. I really love how Attorney Zagala explains everything so beginners like me will understand the law. Well, Jovi, thank you so much for that feedback. But all of our sessions, all of our workshops, articles, they are created for beginners talaga by design. So we love the fact that you appreciate that. And now, I also get comments, Attorney Ramon, na parang, legal guide, bakit yung mga tanong ninyo parang binabasa ninyo yung nasa isip ko? But parang swak to swak? Well, that's precisely because yung mga tanong po na sinasagot namin on our episodes are questions submitted by readers and viewers just like you. So talagang parang binabasa namin kasi sa inyo nanggaling yan. So if you want to submit a question yourself, just go to our website and click the submit topic button. Who knows, baka yung next episode, yung tanong mo na yung ma-feature namin. So let's get on with the show.
This episode is brought to you by the Complete Employee Discipline System, a book that teaches owners, managers, and supervisors how to handle any offense easily and systematically. It provides step-by-step procedures from incident reports all the way to the clearance process. Stand your ground and discipline with confidence. Go to info.legalguide.ph/discipline to learn more. Welcome to Legal Guide Philippines, where we simplify the law to help you make better choices. I'm Attorney Ramon Ramirez, and I'm with my partner,
Attorney Erwin Zagala. So today, we're talking about getting terminated for gross and habitual negligence.
Naku, ayun
Yeah.
na.
So sa Tagalog, ano bang ibig sabihin yan?
Matanggal ka dahil naging pabaya.
Pabaya. Okay. So let's answer that first question because answering this first question will give sense to the whole question given by Angelique. Diba?
Right. Oo.
So pwede ka bang matanggal due to negligence? The answer is yes. Neglect of duty is a just cause under the labor code. So that's under article 282 of the labor code. Ang employer po pwedeng mag-terminate for any of the following causes. So marami po yan, ha? Serious misconduct, willful disobedience, gross and habitual neglect is one of these. Okay. So let's break it down even further. Babasahin ko ng ng mabagal para ma-emphasize yung mga important points.
Okay.
Gross and habitual neglect by the employee of his duties. Okay. So isa-isahin natin. Gross, ibig sabihin, mabigat.
Okay.
Mabigat. It implies
Gross.
No. It implies a want or absence of or a failure to exercise slight care or diligence or the entire absence of it. In short, naging pabaya.
Naging pabaya. Hindi lang slight, talagang wala.
Wala.
Pwede. Oh.
No. Pwedeng nagkulang or talagang wala. Kulang ka ng ng pag-iingat. It evinces a thoughtless disregard of consequences without any exerting any effort to avoid them.
Walang pakialam sa outcome.
Walang pakialam, walang malasakit.
Okay.
So yun ang naging epekto. So that's the gross part. Let's talk about the habitual.
Habitual.
Okay, ibig sabihin naman ng habitual, repeated failure to perform one's duties for a period of time, depending upon the circumstances.
So, attorney, hindi pwedeng one time, big time lang.
No. Ano ang basis ko dyan? And kasi nakasulat. So, gross and habitual neglect. Ibig sabihin, mabigat at paulit-ulit yung pagiging
Alright.
pabaya. Now, so lumalabas, a single or isolated act of negligence does not constitute a just cause for the dismissal of the employee. So, kunwari, nagkamali ka ng isang beses, hindi naman ganun kabigat yung batas na bawal magkamali.
Tanggal ka agad.
Diba? Naku, hindi ako naka-time in. Diba? Or, naku, hindi ko na-submit yung isang report. Hindi naman ibig sabihin nun na
Tanggal
ka na kagad. Okay? But there is an exception.
Okay.
Dito. So, to be clear ha, pinag-uusapan natin the general rule. Gross and habitual.
Okay. Grabe, mabigat at paulit-ulit.
Paulit-ulit.
Okay.
There is an exception under the law. Kapag yung grossness sobrang bigat, hindi na kailangan ulitin para masabing negligent ka.
Okay.
I don't recall the exact GR number, pero I think there was a case before wherein a teacher naging pabaya. Field trip ng mga bata. Dahil naging pabaya yung teacher during the field trip, may isang batang namatay.
Nakain ng leon.
Nakalimutan ko yung exact na nangyari, pero well, namatayan siya ng estudyante because of neglect. Now, ang sinasabi ng batas doon, wait, negligence yan. Pero I don't think kailangan hintayin pa natin yung habituality. Hintayin natin yung susunod.
May mamatay ulit na bata.
Bago ka ma-terminate. No. So that's an exception. If the grossness is so huge, hindi na kailangan na umulit-ulit yon to be a ground. Okay? But for all other matters, hindi naman ganun kabigat, gross and habitual. Now, itong ganitong klaseng behavior, Attorney Ramon, nagpa-manifest in different ways. Kung mapapansin mo, iniwan talaga ng batas na open-ended in description. Okay? So, hindi na sinabi, for these specific instances of negligence.
Right.
Open-ended. Para bahala kang i-apply kung pasok yan doon. So, to give you guys a flavor of how gross and habitual neglect really appears in the real world, we thought of 3 examples. Usually, ito yung mga na-encounter namin. I don't know for other companies, lawyers, or other managers, but for us, ito yung usual na encounter namin with our clients and students. So we decided to use them as examples. The first, ito, starts with an A. Marami natatanggal dahil sa gross and habitual negligence.
Alcoholism.
Hindi. Yes? Kasi serious misconduct yun.
Okay.
Pumasok ka ng lasing, serious misconduct yun.
Okay.
Ito, mas matindi to kasi para siyang langgam. Diba? Langgam, di ba? Hindi naman nakakapatay kung may isang kagat eh. Pero kung kakagating ka tuloy-tuloy, di ba? Magkaka-effect eh. In the same way, itong behavior na to at work, one time, hindi mo mararamdaman. Pero pag paulit-ulit, talaga matatanggal ka. And it's absenteeism.
Yun. Palaging absent.
Palagi kang absent. At hindi lang, kunwari, palagi kang absent, palagi ka pang absent na walang ground or notification. Yung bigla ka na lang na mawawala, di ba?
Naku, nababalitaan ko yung mga ganyan tao.
Ewan ko na lang kung talagang hindi mapikon sa'yo yung amo mo, di ba? Kung ganyan ka naman gumalaw. So one time, di ka naman matatanggal yan. Pero kung sakaling, linggo-linggo lang may absent ka, or hindi ka man lang nagpapaalam, or you don't go through the proper policy, may policy kayo kung paano mag-apply for leaves, hindi mo sinusunod, pwede ka talaga matanggal under gross and habitual neglect. Bakit? Sa dami ng absent mo, naging gross na, and habitual siya kasi paulit-ulit na ginawa.
Nice.
Next naman is wrong reports.
Wrong reports? Bakit?
Kung titignan mo, minsan, parang hindi naman ganun kalaking issue yan eh. But in some instances, it is. For instance, yung trabaho mo, talagang kinuha ka para ma-purify or to get accurate records. Yun talagang essence ng trabaho mo. For example, payroll.
Ay, mga compenbent. Okay.
Every payroll period na lang, either kulang or sobra ang sweldo mo. So, the company ends up refunding or actually has to redeposit kung ano man yung
Parang
kulang.
may mga kilala akong ganyan na naka-experience na yata ako ng mga ganyan.
Oo. Kung paulit-ulit
Mm.
naman na gano'n, sandali, medyo may problema tayo dyan.
Mm.
Or kunwari, ikaw yung quality control or inventory sa warehouse, di ba? Mali-mali yung bilang. As a result, nagiging mali yung reordering level. Ang daming surplus na pumapasok dahil sa kagagawa ng report mo.
Or shortages.
Or shortages, di ba? Tingin ko pwede ka talagang tamaan dyan for gross and habitual neglect. Lalo na kung paulit-ulit yun. Another example is, kunwari, nasa sales. And paulit-ulit din na hindi mo naaabot yung quota for the month.
Yung minimum. Yung minimum quota. Okay.
Oo. So kung sakaling pinagbigyan ka na, inayos na, hindi ka pa rin umaabot, ay, pwede ka talagang tamaan yan for gross and habitual neglect because you're unable to perform as specified. Okay? So I hope you guys are getting a good flavor for gross and habitual neglect, what it looks like in the real world. Now, let me connect that to our question for this episode.
Ni Angelique.
Oo. So sabi niya, I was terminated for alleged neglect of duty. Now, tama ba yung ginawa ng employer niya? The answer is, we don't know. Why? Kulang po yung details.
Right.
Okay. But the intention in this episode is to give you the layout under the law. Kung medyo pumapasok tayo dyan sa gross and habitual based on our explanation, then tama po yung ginawa ng employer. Now, after that, sinasabi ni Angelique, parang bala ko na mag-file ng illegal dismissal. We will tackle that later on after the break when we handle the process for termination. So, welcome back. Ito na, Attorney Ramon. So, we tackle the second part of Angelique's question, which is, I'm planning to file for illegal dismissal. Kasi feeling niya parang mali yung pagka-terminate sa kanya. So, ano po ba dapat ang proper na procedure para masabi na, ay, tama nga yung ginawa ng employer ko.
Okay.
Talagang rightful yung termination. Okay. So under the labor code, sa implementing rules, may standards po tayo ng due process na sinusunod. So may notices na kailangan para po ma-terminate ang isang empleyado. Okay? In all cases of employment, the following standards shall be observed. Number 1, there should be a written notice served on the employee specifying the ground or grounds for termination and giving to the said employee a reasonable opportunity within which to explain his side. We discussed this in another video, Attorney Ramon, di ba? How to properly terminate an employee. And this is what you usually call a notice to explain. So, kumbaga parang ito yung asunto. Di ba? Binibigay mo sa employee, Mr. or Miss Employee, ito yung violations mo.
Okay.
Submit an explanation bakit hindi ka dapat mabigyan ng penalty as a result of that.
Yun.
Yan.
So, yun yung first thing, yung asunto or yung notice to explain. Tama?
Ang next naman na requirement, a hearing or conference during which the employee concerned with the assistance of counsel, if the employee so desires, is given the opportunity to respond to the charge, present his evidence, or rebut the evidence presented against him. So basically, may pagkakataon po na magpaliwanag.
Yun.
Diba? So, pwede siya mag-submit ng evidence, written, pwede siya magsalita kung ano yung gusto niya idagdag. Walang problema, basta't mapagbigyan po siya ng opportunity to be heard.
Very important. Yeah.
Now, third is the written notice of termination served on the employee, indicating that upon due consideration of all the circumstances, grounds have been established to justify his termination. Now, in case of termination, the foregoing notices shall be served on the employee's last known address. Okay, so para masabi mo na tamang na-terminate ka, kailangan dumaan po ng prosesong yun. Nabigyan ka ng notice to explain, nagkaroon ng opportunity to be heard during a hearing, or actually it doesn't have to be a hearing, basta't may opportunity to be heard. And then finally, a notice of termination. So, Angelique, kung sumunod po yung employer ninyo sa prosesong yan, then we can say tama po yung ginawa. Kung hindi, then hindi. Then you may have grounds to file for illegal dismissal.
And this one, diniscuss mo, Attorney Aaron, this is the procedural part of it. Diba? Yung unang part was yung substantive part.
Yes.
Sabihin yung may laman ba? May rason ba?
The right reason
Yan,
to terminate.
Oo.
Ito naman, the right way of terminating.
Yun. So, kailangan meron yung pareho, Attorney Aaron.
This is something we discuss extensively dun sa book na binention natin kanina. Now, before we leave this topic, I want to give some additional tips. Attorney, yung gross and habitual neglect, basta-basta ba yan? How do we show that in the notice na talagang gross nga and habitual? So what I would recommend is documentation for a period of time. So kung kunwari, madalas yung absent ng mga tao, madalas yung pagkakamali, you document that, iipunin mo ngayon yan. So the next question necessarily is, attorney, how long? Depende. It's a case-to-case basis. You might want to consider consulting your HR or legal team for this, but it's a case-to-case basis. Kunwari absent, for me, 3 buwan na ganun yung pattern ng absences, that might be enough. Or kung kunwari yung wrong reports, siguro 1 quarter to 2 quarters na, sandali, consistent na every month may mali ka. Or yung quota, sandali, 3 buwan ka nang walang naipapasok na benta. Diba? And in addition to that, some HR managers, they implement what is called a PIP.
Ano yung PIP?
It's a performance improvement program. So kumbaga, hindi dahil nagkamali ka, hop, dali ka na. No, we'll give you one last chance. So a PIP is a certain period of time wherein todong nakatingin sa'yo yung immediate supervisor mo or manager, giving you the tools for you and the chance for you to improve. So, sige, bibigyan kita one last month. O ano ba ang kailangan mo para maayos yan? Anong support ang kailangan mo? Pag hindi pa rin, we'll have to terminate you.
Oh, that's nice. That's a nice program.
Oh,
Kaysa kagad, penalty kagad.
What I like about it, it's fair on both sides. It's fair to the employee kasi ikaw na nga nagkamali, binigyan ka pa ng one last chance, di ba? So, tingin ko tama lang yun, di ba? Ngayon, kung ikaw mahal mo yung trabaho mo, you would grab the opportunity.
Yeah, true.
Ngayon, kung ikaw talagang, kung tama yung accusations and talagang walang kwentang employee yung nakuha or talagang ayaw mo na dun kaya pangit na yung performance, lalabas at lalabas yun. Diba? So on one side, it's very fair. Kung gusto mo kasi yung trabaho mo, it's one last chance to do a good job.
Right.
On the other hand, it's also a win for the employer. Why? Because during that time, pwede nang i-document yung performance ng employee. So bago siya maglabas ng notice to explain, kitang-kita, ito, pinagbigyan pa nga namin one last time. So, litaw na litaw sa papeles. The paper will not lie. Diba? It will not conceal any mediocrity or inefficiency. Lalabas at lalabas ang totoo.
True.
So, that's why I like that. Now, we'll be taking a break in a bit, but after the break, we'll talk about the rest of Angelique's questions, namely sa quitclaim and sa COE. Stay tuned. So, Attorney Ramon, let's proceed with the second part of Angelique's questions. Yung tungkol dun sa quitclaim tsaka waivers and yung mga request niya na ayaw ibigay sa kanya.
So, ano nangyayari here, Attorney Erwin?
So,
kailangan na niya yung humihingi siyang COE.
Certificate of Employment.
Right.
It's proof na nagtrabaho ka talaga dun sa isang kumpanya or employer.
Ay, ano sabi ng employer niya?
Ay, hindi ko ibibigay ito. Not unless you sign a quitclaim. So ano po ba yung quitclaim? It's a statement of you saying na, sige, natanggap ko na po itong perang ito, and then dahil natanggap ko na to, wala na po akong habol dito sa employee ko.
Yan.
Okay. Now, there are certain requirements under the law para maging valid yung quitclaim. And just to be fair, okay lang ba yung quitclaim? Yes, it's perfectly legal as long as etong mga requirements na to nandito.
Important.
Number 1, there was no fraud or deceit on the part of any of the parties. Walang lokohan. Kumbaga pinasok with full knowledge and consent. Talagang alam ko yung pinapasok ko. That's why sometimes, Attorney Ramon, yung tip ko, yung mga quitclaim, lalo na kapag hindi English speaking yung empleyado, gawa kayo ng quitclaim na Tagalog. Para hindi masabi na, ay, hindi ko po naintindihan yung pinirmahan ko.
Basta pinapirma na lang sa akin
Para maiwasan yung mga ganong klaseng allegations. Requirement number 2 for the quitclaim, that the consideration for the quitclaim is sufficient and reasonable. Yung medyo nasa katotohanan naman. Hindi yung, sige, hindi na ako maghahabla ng kaso kasi binigyan ako ng 5 pesos.
Okay.
Kasi kung sakaling umabot tayo sa korte, makikita ng korte yun na parang seryoso ba itong parang naglolokohan naman to, diba? So it has to be sufficient and reasonable. Okay? And then finally, that the quitclaim is not contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Ibig sabihin, hindi po labag sa batas yung quitclaim. Okay. Ang quit claim po, hindi rin siya 100% na guarantee on the part of the managers. Kasi there have been cases wherein the courts have invalidated questionable transactions.
Or questionable quitclaims.
Yes, especially when there's a clear proof that the waiver was, well, obtained from an unsuspecting or gullible person, or where the agreement or settlement was unconscionable on its face.
So, pwedeng ma-invalidate pag kunwari, mukhang madaling maloko tong ano, and mukhang niloko nga.
Niloko, or yun nga yung mga requirements na pinag-usapan natin kanina, di ba? Na sobrang baba naman yung binigay na consideration. Ano klase ito, di ba? Okay, so having said that, let's put that into context. So sinasabi ni Angelique, humihingi siya ng COE, ITR, final pay, I'm guessing. Pero kailangan daw pumirma ng quick claim. Okay, is this proper? Let me tackle it segment by segment. Kasi mahirap maintindihan kung hindi natin segment by segment na itatakal. So, is a quit claim required for the certificate of employment? No, it is not. Ano po ang certificate of employment? Sabi po namin dun sa isang video namin, ang certificate of employment para po siyang resibo. Para siyang
resibo.
Ibig sabihin, resibo na nagtrabaho ka dun sa isang lugar. It is not dependent. Wala po sa batas na nakasulat na kailangan pumirma ka ng quit claim para makuha mo ang certificate of employment. In fact, Attorney Ramon, kahit nagtatrabaho ka pa sa isang employer, pwede ka humingi ng COE.
So, because all the COE will say is, on this date to this date, this person was my employee.
In this position.
Yeah.
Hindi sinasabi ng COE na, wala nang claim to sa akin. Di ba? Nakuha na niya lahat. Baka iba po yung tinutukoy, baka clearance. Iba po ang COE. COE can be asked anytime. In fact, under department order po ng DOLE, if I'm not mistaken, 3 days. Kailangan ilabas yan. Okay, so insofar as the COE is concerned, hindi po required yung...
So, hindi pwedeng ma-hold up yung COE just because hindi pa pumipirma ng quit claim. Tama po ba, sir? Okay.
Let's go to the second one, ITR. Or
ITR.
What is ITR? It's income tax return. Ibig sabihin, ito po yung fina-file sa BIR. Now, is a quit claim required for the ITR? Okay, so medyo may complication dito ng konti. Konti lang naman, pero hindi insurmountable. Kasi, dun sa ITR, lalabas lahat ng kinita mo na winidhold ng employer mo.
Yung kinita plus yung winidhold.
Kaya lang, paano malalaman ng employer kung ano yung ilalagay sa ITR kung hindi pa nga buo yung dapat na binigay sa'yo? Kasi nga, hinihintay na tanggapin mo. So for me, ang advice, medyo a little bit on the gray area.
Yeah.
Hindi siya parang tama or mali. Advice ko, pag-usapan na lang to. Kasi kung sakaling you're able to receive, that can be reflected in the ITR. Makukuha mo yung ITR. Pero to be clear, hindi po requirement na pumirma ng quit claim bago matanggap ang ITR. So maganda pag-usapan na lang po ito. Baka naman you guys can come to a reasonable solution. Okay, so natapos na natin COE, ITR. Ano yung panghuling tinatanong ni Angelique? Parang yung pagpirma mismo ng quit claim, di ba? Ngayon, kung ayaw mo pirmahan yung quit claim, pwede namang hindi. And kung sakaling ayaw yung final pay pala, okay, kung ayaw mo na pumirma ng quit claim, hindi makukuha yung final pay, the right solution would be to ask for assistance sa DOLE. Kasi hindi ka pwedeng pilitin pumirma ng quit claim kung ayaw mo. Okay? Hindi siya requirement. Ngayon, kung ayaw mo talagang pumirma, you can always ask for assistance sa DOLE. And there, pwedeng in front of the mediator or in some cases, arbitrator, kung umakyat na yung kaso, di ba? You guys can exchange the things that you need to. Kasi ang ibig sabihin lang naman ng quit claim, wala ka nang hinahabol at wala ka nang ikakaso. Ngayon, kung may hinahabol ka pa, then probably tama nga yung strategy. Huwag ka nang pumirma ng quit claim. Yun nga lang, on hold mo na yung final pay mo. Parang si employer kasi nagtataka rin, ano pa ba hinahabol mo?
Yeah, and
diba?
Yun naman yung part nung minsan standard siya for employers, di ba, na when they give the final pay, may quit claim. Basically, kasi tinatanggap nung employee na wala na siyang ibang hinahabol. So kung ayaw mo naman pumirma ng quit claim, parang what's happening? What's going on? So yun naman yung other side of it.
Ako naman, I want to give some advice sa mga employers na parang, ano ba bang gusto mong habulin? Ba't ayaw mo pumirma? sometimes I advise employers to seek assistance as well. Pwedeng pumunta ang employer sa DOLE. Doon kayo para at least taga-DOLE mismo yung witness ninyo na talaga nagkapalitan, and then, ito na, papirmahin mo na. Ano pa ba hinahabol mo?
Yeah.
Wala na po. Sige, pumirma ka na. So that can also be a solution. It's done, and the government is very happy to accommodate that in certain cases. Tingin ko rin, Attorney Ramon, ito commentary lang and an observation. Minsan may inherent distrust yung mga employees na sa pagpirma ng quitclaim. Ang ibig sabihin lang naman ng quitclaim, ito po yung natanggap ko, kumbaga parang resibo rin eh. Wala na akong hinahabol Kung sakali kasi may hinahabol ka, then I think it would be best to identify that. Kumonsulta ka ng abogado. Pero tingin ko di rin naman reasonable yung parang feeling ko lang may dapat pa akong habulin na ano, in a way you're making the exit procedure difficult for both parties.
Right.
So for me, kung may feeling mo alanganin ka, it's best to consult a lawyer or to consult DOLE. Pero if you hold mo yung buong process just because of a feeling, parang unfair din sa employer kung sakali.
And that's why it's important to know, meron ka ba bang hinahabol?
For most of you, this video was more than enough, and if it makes your life easier, then you're welcome. But there are those of you who will watch this video and end up asking more questions, such as, Attorney, what is the format for the notices? What should I write there? How do I serve it properly? If that's you, then I invite you to check out the Complete Employee Discipline System book, where we teach you our roadmap for handling employee discipline cases from start to finish. Get the book now at info.legalguide.ph/discipline today.
Now, to add to that, people say that our show seems to read what's on your mind and then answers them. Well, that's because we base our show on submitted questions from our viewers like you. So please tell us what you want us to talk about by going to www.legalguide.ph and click the submit topic button. Now, if you want to get a shout out in our show, please give us feedback at info.legalguide.ph/feedback so we can read what you found helpful and acknowledge you properly. Now, last, if you feel that we earned a good rating, please give us a like and subscribe because it gives us feedback and it notifies you about our upcoming videos.
One last thing, nobody has to put up with bad behavior at work, but everyone deserves a fair shot at clearing their name in case they are innocent. That's what due process is for. So if you're an employee, do the best you can so that you can show how much you value your job. For employers, let's try to give as many chances for employees to prove themselves. If all of that fails, then we let the law take its proper course and lead to a proper termination. So was it that simple?
Now go make better choices.